So my organization, the Lawyers Committee for 9/11 Inquiry, is contemplating, in terms of future actions, several things. One is that we're considering a request for a federal grand jury. We're also considering future civil litigation, as Daniel Sheehan has explained at some length. We're also considering filing a felony complaint in New York, which you'll hear a little more about. And as Judge Impassamato has noted, we are also considering an international forum for a possible prosecution. Now, under the, so let me see if I can get on the right slide here. Okay, so the first federal law I want to bring your attention to, and this is as much for the panel as for the audience. This is Title 18, U.S. Code, Section 2332F, bombings of places of public use, government facilities. This is one of the terrorism statutes. It defines it imposes criminal liability on anyone who unlawfully delivers, places, discharges, detonates an explosive or other lethal device into or against a place of public use. Now, as I go through these definitions of crimes, of course, I want you all to keep in mind the evidence you've heard today, and perhaps some of the evidence you've heard yesterday. There has to be an intent to cause death or serious bodily injury, or if there is no such intent, there at least has to be the intent to cause extensive destruction of the place where such destruction results in major economic loss. And if those standards are met, then that crime could be prosecuted. There has to be certain conditions met for federal jurisdiction regarding this particular crime. I won't go into all the technical legal details. If the offense takes place in the United States and it is committed in an attempt to compel the United States to do or abstain from doing any act, then there's jurisdiction. Now, you might wonder why I mentioned that, but there is one of the areas we're inquiring into is whether the buildings were destroyed, as explained by the scientific witnesses, in order to motivate the United States government to engage in one or more wars, which we did see progress after this crime was committed. So in my view, jurisdiction would be present on that basis. There's an alternative basis for jurisdiction if you did not accept that basis, and that is that one or more victims were from another state, in this case, state in quotation marks, meaning another nation, another country. That condition is unfortunately satisfied here as well. There are some exemptions to jurisdiction that don't apply here. Because we are short on time, I'm going to not go into those details, but the panel members can grill me on that later, and these slides will be posted on our webpage, www.lawyerscommitteefor9-11inquiry.org. So if you need to see the details later, you can find it there. The next federal law we'll talk about is same title, 18 U.S. Code 2332B, Act of Terrorism, Transcending National Boundaries. This law applies only when one of the perpetrators has done something across the boundary of a nation. It involves killing or otherwise injuring seriously a person, or doing something that creates a substantial risk of that type of injury, or damaging any structure within the United States in violation of the laws of any state or the United States. If those conditions are satisfied, there is a crime. And as with many laws, and essentially every law in the federal system, anyone who attempts to commit the crime has criminal liability. And so keep that in mind as we go forward. There are jurisdictional requirements. As I mentioned, hang on. Let me get my... Okay. So we have acts of terrorism. We got that. So we want to go, sorry, being slow here. Another crime which could be involved in these particular acts we've been talking about has to do with destruction of government property. You might wonder why I mentioned that, because these were the World Trade Center buildings. In a couple of those buildings, as I understand it, my colleagues will correct me if I'm mistaken, federal agencies had offices that they were renting, and of course they had their own property in the buildings. So there was likely jurisdiction for this crime as well, willfully injuring or committing any depredation against any property of the United States or any department. I mentioned in relation to the other law that if you're attempting to commit the crime, there's liability. There's also liability for co-conspirators, accessories, and those who aid and abet. Similarly, if someone provides material support to another person who commits one of the crimes I've mentioned, in this case the terrorist crimes, they also have liability. Material support can include giving money, it can include giving training, expert advice, explosives, transportation, or other support. There's another law that some of you may not realize why it would apply, Title 18, Section 1114, Protection of Officers and Employees of the United States. Whoever kills or attempts to kill any officer or employee of the United States is, of course, committing a crime while such officer is engaged in or account of their duties. You may not remember, unfortunately, again, that there was one FBI officer who was killed in the buildings when they were destroyed, and there was one Secret Service officer who was killed. So in my view, this law would apply. There is, most of us are familiar with the concept of treason. It is a federal statute, Title 18, Section 2381. Anyone owing allegiance to the United States who levies war against the United States or adheres to their enemies, giving them aid and comfort within the United States or elsewhere, is guilty of treason. Most of us know this crime has a death penalty as an option. There are some ins and outs of the treason law we don't have time to go into, but it is one that I think we'll be looking at. This general conspiracy statute, which is still Title 18, Section 371, conspiracy to commit offenses or to defraud the United States. Essentially, it is a crime to conspire to commit one of these other offenses if any one of the persons in the conspiracy does any one act to affect the object of the conspiracy. The next statute we'll look at, which we'll be examining, is called misprision of a felony. And this one is worth some careful thought. Whoever having knowledge of the actual commission of a felony, we're not talking about doing the crime, we're talking about having knowledge of the crime. Whoever has knowledge of the actual commission of a felony, who conceals and does not, as soon as possible, make known the same to some judge or other person in authority, is guilty of this crime. So anyone who came to know of these crimes would have liability under this statute if they did not relay their information as quickly as possible to the proper authorities. I mentioned this earlier. This is the statute that says it, Title 18, Section 2. Anyone who aids, abets, counsels, commands, induces, or procures the commission of a crime is punishable as if they'd committed the crime themselves. That's Section A. Section B, if someone causes an act to be done, which if directly performed by that person would be a crime, that person who caused the crime to be committed is also guilty of the crime. We also have obstruction of proceedings before departments, agencies, and committees. It is a crime if someone corruptly influences, obstructs, or impedes, or endeavors to influence, obstruct, or impede the due and proper administration of the law under which any pending proceeding is being had before any department or agency of the United States. For example, in my view, an FBI investigation, a commission, maybe the 9/11 Commission proceedings, and also if anyone corruptly obstructs, influences, or impedes the due and proper exercise of the power of inquiry under which any inquiry or investigation is being had by either House or any committee of either House or any joint committee of the Congress. What comes to mind there might be the joint inquiry that was done in 2002, 2003. So anyone who does that is committing a federal crime. Now, there are some statute limitations. I won't spend a lot of time on this, but most of you know if you wait too long, you being the prosecutor, you may lose your ability to prosecute a crime. That is only true for some crimes. The first statute I will bring to your attention on this is capital offenses. It probably won't surprise you that if an offense has a death penalty associated with it, that there is no statute of limitations. The crime can be prosecuted at any time. Now, the general statute of limitations, which comes under Section 3282, is 5 years. But if you'll notice the beginning clause there, except as otherwise expressly provided by law. So it's 5 years unless there's another law that provides otherwise. I just gave you one law that provides otherwise, which is for capital offenses. Now, let's look at another statute. This is Section 3286 of Title 18, extension of statute of limitations for certain terrorism offenses. Now, Section A extends that 5-year period to 8 years, but Section B is the one of most interest to us given the time frame in which we're now working. And Section B says, as you can see, hopefully, no limitation, notwithstanding any other law, an indictment may be found or an information instituted at any time without limitation for any offense listed in Section 2332B, G5B, and I'll just tell you to save us some time, that list referred to there includes the 2 terrorism offenses I presented to you earlier. So in this case, if, as it says here, the offense listed, and I've presented 2 of them to you under the terrorism statutes, if they resulted in or created a foreseeable risk of death or serious bodily injury to another person, then there is no time limitation for their prosecution. There's another exception that I'll mention, and I'll go on to talk about the grand jury, and that is if someone is fleeing from justice, and there are some ins and outs of how the law defines fleeing from justice, but if someone attempted to conceal themselves after these crimes, the statute of limitations would not run on the crimes that they committed. I want to move now to a brief discussion of standards applicable to grand juries, because that is one of our anticipated future actions, which is a petition for a federal grand jury, a New Jersey grand jury, and a New York felony complaint. Now, the law I'm about to give you quickly is only for federal grand juries. My colleagues will be talking about New York and New Jersey. So the grand jury requirement, as most of you know by now, comes from the 5th Amendment of the U.S. Constitution, so it's a requirement based in the Constitution itself. The only way someone in this country can be prosecuted federally for a felony is if a grand jury makes a presentment or an indictment, which basically says the grand jury has found in its own judgment that a crime has been committed and that this suspect is responsible for the crime. So it's a constitutional requirement and entitlement for anyone who is to be prosecuted for a felony. Now, some of the rules in the federal system, and you may not realize this, the grand jury is to act independent of both the prosecutor and the judge, which means the prosecutor under the law cannot tell the grand jury what to do or not to do. Neither can the judge. Now, you'll probably hear some discussion later that the system doesn't always work as defined, but this is how the law is stated. The grand jury is independent. It's not, as the next quote I have here says, not captive to any of the three branches of government. It is a constitutional fixture in its own right. The purpose of a grand jury, its mission, and its duty is to determine whether there is probable cause to believe that a crime has been committed, one, and that a suspect in particular has committed the crime. Now, what that doesn't mean, however, is that for a matter to be presented to a grand jury, the persons bringing the evidence forward, perhaps such as our lawyers committee, has to have named a suspect already. The grand jury can pursue an investigation to identify the suspect or not. So, but before a grand jury can make a presentment for an indictment, they have to, in their own view, determine probable cause that a crime was committed and that a particular suspect had committed the crime after they finish their inquiry. Now, the grand jury has broad investigatorial powers into what might be federal crimes. The grand jury does not have to rely on the prosecutor to tell it what evidence to inquire into. Again, there may be some slippage in terms of actual practice with grand juries and whether the grand jury is actually well educated on its powers and is allowed to exercise them. But under the law, the grand jury can pursue its own investigation. There is some distinction to be made, which we probably don't have time for, unfortunately, between presentment and indictment. It's an important question. We may get into it in the discussion. I'm going to skip over that one. So let's look at what is it that the grand jury is allowed to look at. So the Constitution does not prescribe or proscribe what kind of evidence the grand jury can look at. It can look at whatever it wants to look at. I mentioned earlier it's allowed to look at hearsay evidence. That is the law in the federal system. The grand jury does not have to go by the federal rules of evidence. That comes later if there's to be a trial. So the grand jury's scope of inquiry is broad and it's flexible, and it's up to the grand jury to decide what to look at. Any evidence that reasonable people might use to reach a logical conclusion is allowed to be examined by the grand jury under federal law. So this is redundant, but it's important that you understand this. The Fifth Amendment does not say that only admissible evidence or legal evidence may be received by the grand jury. It does not say that. So let's go on to a new point. Now, if a grand jury makes a presentment leading to an indictment, the defendant can be tried, even though, as this case I'm citing here, I'm not giving you the citations, it'll be on our website. These are all federal cases. Even if the evidence and allegations are what we might call minimal under the law, if the grand jury decides they're persuaded, that's enough for the trial to go forward and the indictment to go forward. There's no requirement that the evidence be of any particular kind. Hearsay is allowed, as I mentioned. And there is even a case that says even an indictment based on hearsay, incompetent, and inadequate evidence would not be void. The key here is this is the grand jury's job. It's not a judge's. It's not the prosecutor's. So the grand jury makes up their mind whether the evidence is sufficient for a presentment to lead to an indictment. So keep these standards in mind as you think about the evidence you just heard.